Congress impeach a sitting justice of the Supreme Court, Samuel Chase. 4 articles of impeachment focused on procedural errors. Another article of impeachment was directed as it had his, quote, intemperate and inflammatory, peculiarly indecent and unbecoming, highly unwarrantable, highly indecent remarks while authorizing a Baltimore grand jury. Vice President then Aaron Burr presided over the trial. Chase was acquitted. But the trial helped solidify a sense of judicial independence. The Taney Court, 1836-1864, made several important rulings. One, that Congress may not limit the subject matter that the Supreme Court may hear. They're most known for the Dred Scott versus Sanford decision, a case which may have helped precipitate the United States Civil War. In Dred Scott, that decision ruled that African Americans, being considered, quote, of an inferior order and altogether unfit to associate with the white race, unquote, at the time the Constitution was drafted, could not be considered citizens of the United States. In the years following the Civil War, there was the Chase, Waite, and Fuller courts. It takes us up to about 1910. This is Solomon Chase, interpreted more of the Civil War amendments, of which we can get into that a little bit later during the discussion if you like, and began codifying something known as the due process doctrine. Under the White and Taft courts, this is Taft, the due process doctrine was applied, and the court held that the 14th Amendment applied some provisions of the Bill of Rights to the states. All right, this guy was also president. You probably all know that. He had a lot of titles. He was during the Hughes, Stone, and Vincent courts. The court moved to this building that was built in 1936, the building that we all know now, and seemed to mollify its interpretation of the Constitution relative to Roosevelt's New Deal. It gave an expansive reading to the Constitution in terms of the federal government and what the federal government could do. A little bit more recently, this is Earl Warren, 1953 to 1969, made many alternately celebrated and hated, but no doubt controversial rulings, expanding the application of the Constitution to civil liberties, leading what some would call a renaissance in due process. It held that segregation in the public schools is unconstitutional in Brown versus Board of Education, that the Constitution protects a general right to privacy in Griswold, public schools cannot have official prayer in Engel, or mandatory Bible readings, Abington School District versus Shemp. Many guarantees of the Bill of Rights apply to the states in MAP. There was the Miranda ruling. An equal protection clause is not contained in the Fifth Amendment, and that the Constitution grants the right of retaining a court-appointed attorney for those unable to pay for one, even for non-capital crimes, in Gideon versus Wainwright. Earl Warren had his detractors. Many wanted to impeach Warren for his nasty rulings from the bench and what the court did. It was serious business then, as we have that discourse today. The Burger Court, Warren Burger, 1969 through 1986, ruled that the Constitution protected a woman's right to privacy and control over her own body, striking down the abortion bans in Roe v. Wade. He reached another controversial rulings on affirmative actions in the Bakke decision and campaign finance, and ruled that methods of several states to implement the death penalty were unconstitutional. To give you one quick example, a man named in Georgia, Furman versus Georgia, Furman was burglarizing a private home when a family member discovered him. He attempted to flee, and in doing so tripped and fell, and the gun he was carrying went off and killed a resident in the home. He was convicted of murder and sentenced to death. Now the question before the court was, does the imposition and carrying out of the death penalty in this case constitute cruel and unusual punishment in violation of the 8th and 14th Amendments? Their conclusion, yes. So what they said was, and they argued this, and they discussed this, but the majority opinion said, yes, in this case it does. Two justices, Justice Brennan and Marshall, believed that the death penalty should be unconstitutional in all instances. But the court also ruled that the death penalty itself was not unconstitutional. Now, we move to the Rehnquist court. Justice Rehnquist liked to wear the stripes. Those stripes are optional, that he wore the stripes. Seemed to further the concept of a big, strong federal government and a powerful executive branch, which included restrictions on congressional power under the Commerce Clause, and known for the big decision that we all know about, Bush v. Gore, which ended the electoral recount during the presidential election of 2000. But the Rehnquist court also decriminalized homosexual sex in Lawrence versus Texas, but also restricted abortion and abortion in terms of notification in Planned Parenthood versus Casey. Then we move to what we have today, the Roberts Court. All right, the court under Chief Justice Roberts is perceived as being more conservative than the Rehnquist court. Some of the major rulings so far have been about abortion and Planned Parenthood versus Gonzalez, antitrust legislation, more on the death penalty. There's some things on due process relative to what is happening in Guantanamo. There's a lot of issues going on where people generally disagree. And we can argue whether there's a genuineness and a sincerity on some sides, but they generally disagree on what's happening, and we go to the courts for the arbitration and the settlement and making their judgment on and they're offering their opinions, and that becomes the law until they change their mind. And notice one big case where they did change their mind was in Plessy versus Ferguson, where they had the separate but equal doctrine in segregation. As long as everything was separate and equal, then they ruled that that was inherently impossible to keep things equal in the Brown versus Board of Education, and ruled that that was unconstitutional. Interesting to note, 40% of the Supreme Court decisions, 40% give or take a little bit, are unanimous. What? Unanimous. They all agree. They vote 9-0. Yeah, that's right. This is what we like. 20% come down to that swing vote stuff, that swing vote, where Sandra Day O'Connor was a big swing vote person, and now we have Justice Stevens being a swing vote individual, the guy that makes the decision when it's 4-4, who's going to, how are they going to roll with that. And the other 20% are some other form, 8-1, 7-2, that kind of thing. Now, here are the justices, and they are. We have Stephen Breyer. Well, let's see if I have. Yeah, we have. This is McLeod Kennedy, born. He's 73 years old. This is David Souter, Antonin Scalia, Ruth Bader Ginsburg, Stephen Breyer, Samuel Alito, Clarence Thomas. Let's say happy birthday. Do you know who this is? Stevens, right. He's 89 years old today. This is his birthday. Happy birthday, Justice Stevens. Thank you. And that's a pretty sunrise? I think that's a sunrise. It could be a sunset. I never know. So what I'd like to do is open this up and ask a few questions of you. Why is it important to understand this, to understand the workings of our government? If, I going out and about and talking with people, and I've come to a conclusion that we've raised generation after generation of people who have sort of self-disenfranchised. They have decided that the role of the government has no relative meaning in their personal lives. They don't understand it because they haven't been taught it in their school system. We don't just not teach it. We give it for a semester or so. But to me, this should be something that should be driven home. If for no other reason, there's 100 reasons, but if for no other reason, that it's very, very important in a presidential election to know who you're voting for and why.